All right, it is time to go live. This is Matthew Newsom, the attorney for Surge Business Law, and this is the November 17th Ask Me Anything episode where I answer the questions that you submitted. If you look us up on Facebook is the best place to find it, then you can see I've got a pinned post right at the top of the channel where you can ask questions. They will get put into the next episode because I do like to think about your questions before I answer them. Sometimes the questions are easy enough that I can answer them off the cuff, but sometimes, and today is one of those times, where you guys offer very interesting and challenging questions. So let's not delay. Let's get into the first question. This one was submitted by Sheena Wright, and she asks if landlords can charge RUBS fees or some other kinds of utility charges. And first of all, I know what kind of business she runs, but because we have both commercial and residential landlords out there watching this, then I want you to know that the answer does depend slightly on if you're offering a commercial tenant or a residential tenant a lease. So first of all, commercial leases tend to be very permissive. So the law does not weigh in too heavily on what commercial landlords can do. And so the main thought process here is that as a business owner, you are savvy, you can afford a lawyer, you can afford to get good advice. And so therefore, if you enter into a contract as a business owner, the court's going to say, yeah, well, everybody's savvy. They knew what they were doing. And they'll let you enter into contracts that are kind of detrimental. Hopefully your contracts are not detrimental, but the court permits you to do pretty much whatever you want. However, the court does not have the same opinion about residential tenants. In the residential space, the court considers landlords to be far more savvy. Maybe a landlord can afford a lawyer, whereas many tenants cannot. And so the courts step in to protect tenants from landlords that do unscrupulous things. So we do see laws that influence tenants. So essentially what Iowa law says, and I suspect that this is a similar theme across the country, but if you're not in Iowa, you're going to want to check on your local laws, is that landlords have to disclose to tenants how utility fees are going to work before they sign the lease. And so if you want to do a utility sharing agreement for your tenants, fine, but you just have to make it clear, understandable before the tenant signs the lease. If at some point you need to change the utility situation, then you're going to have to notify the tenants in writing 30 days before the change becomes effective. So take that seriously. If you are doing utility sharing, just make sure that it's as fair as you can, and then make sure the tenants know about it before they sign. And then if you change it, notify them again. All right. She has another question. Sheena Wright, also from Creta Capital, asks this. Can you take photos of tenants' units when doing walkthrough inspections? And this was a particularly interesting question because tenants have a couple rights. So the tenants have the right to privacy in their home, and the tenants also have a right to the quiet enjoyment of their home. And so I can't answer this question very specifically. I can only answer generalities, and that is because every situation is going to be a little bit different. But for example, if the tenant reports a problem with the water heater and the landlord goes into the tenant's unit after either giving 24 hours notice or has been invited, then the landlord takes a picture of the water heater so that they can send it to the plumber. Well, that's not going to be a problem at all. Let's just say, though, that you are walking through the apartment and then you see something illegal. Can you take a picture of that? And in this situation, I had to go look at the different cases that have been upheld, and the courts have basically said that it depends. And I hate it when they do that, but they do often say that. And so if you're breaching the tenant's right to privacy, then there has to be a good reason. And not just their right to privacy, but also their right to quiet enjoyment. And so and this is going to dig into the next question slightly, but if you believe that there's some kind of illegal activity or violation going and you are already permitted to be in the unit because of some other thing and you take a picture, then that will probably, and I'm going to say probably, and that's kind of an important word, not be found to infringing your tenant's rights. But I would not be going into tenants' units and taking pictures and breaching their privacy or waking them up, knocking on the door, going in and going into the units without permission or without either emergency or 24-hour notice, and taking pictures, because you likely will find yourself in trouble, even if you find something illegal. So make sure you enter the unit lawfully, and then make sure that your purpose is just. All right, Sheena Wright's got another question, Sheena from Credo Capital. Dealing with a tenant who is suspected of violating lease terms. And I rephrased that question. She gave me some very interesting answers to her question, or details about her particular question. But here's the situation, and that is that you really have two choices. You can either wait until you have actual evidence that you've obtained in an authorized fashion. Boy, that's a long disclaimer there. You can wait till you have actual evidence, or if you suspect that you have accidents, then you can take a chance and be kind of threatening. So let's just talk about actual evidence. Let's say that you have a tenant in a multi-unit property who says, my neighbor has a dog and dogs are not allowed. And that tenant either takes a picture and sends it to you, or one of your staff members goes there and hears the dog barking or notices it or whatever. And so now you have actual evidence that was obtained in an authorized fashion. Then you're going to want to give them the standard 7-day cure notice to let them know you're in violation of the lease. You now have 7 days to fix it. And if you don't, then you're going to terminate the lease. All right, but what if you don't actually know? Or what if you might know, but you can't prove? Well, you have a problem here, because the proper way to deal with a tenant who's violating the lease is to give them a 7-day notice to cure. Well, how are you going to tell if they've cured it? So if you can't tell if they've actually violated the lease, then you also can't really tell if they've actually fixed the problem. And so the way that landlords typically deal with tenants who violate their leases, they give that 7-day notice. If it's not cured, then they terminate the lease and they pursue a lawful eviction. And the lawful eviction means entering evidence into court. And if you enter evidence that was obtained in a way that is not lawful, and so maybe you broke into their unit or did something in violation of the lease in order to get the evidence, then you're gonna be in trouble there. You're gonna have a hard time getting that evidence admitted, and your case is likely gonna get thrown out. So you do have a little bit of a tough situation. If you find yourself in a situation where you really have a question, you should talk to an attorney, and you should talk to me. Next question, and this was submitted by someone who didn't give their name. What are some ways to save money when starting a business, and how much should I have saved before starting a business? Now, this is an excellent question, and somebody asked this to me in person, and I'm the one that wrote it down, and I paraphrased it. This is a question that you should ask yourself before you start a business. And ideally, you would start with a business plan, and you have figured out, okay, these are my expenses. I'm going to have to pay rent. I'm going to have to pay for software. I'm going to have to buy merchandise. These are the things that I'm going to have to pay for. And I think it might take me 6 months, 8 months, 3 months, whatever it is, to get enough money to start paying the bills. Well, that's how much money you're going to need to save before starting your business. And I can tell you from personal experience, starting this law firm, that you're going to need more than you think. And so it is a very, very good idea to have more in savings than you think you might need. Now the good news is that if you are doing the things that I told you, and so hopefully you've talked to me, watched my videos, read my blog posts, and here's the things that businesses should do. Like, for example, charge a reasonable fee for your services and products, have a good healthy profit margin, and various other things. Then even though your business is not self-sustaining, it should be producing revenue to offset how much money you need to get out of savings. So for example, let's say that in order to run your business, you need $6,000 a month. And after 3 months, you've started to have a steady income of $1,500 per month. That's good. Ideally, after month 2, it would be $2,000, and then it would keep working its way up. but that's another $1,500 you don't need to pull out of savings. So that's a good sign, something that you want to hopefully obtain. Okay, so what are some ways to save money when starting a business? This is what I suggest. I'm going to use this scenario. Let's say that there is a couple and they both have jobs, and one person, he let's just say that he makes $70,000 a year, and the other person, let's say it's a she makes $55,000 per year, and she wants to go start her own business. So the first thing that I would do is I would adjust your budget so that you can reduce the family's dependence on her income. And this is a little bit easier when the person who's giving up their regular income is a lower earner. But let's just say that she's making 75,000 and he's making 55,000, and she's giving up her income. Then you want to reduce your reliance on her $75,000 income. That is difficult. You're going to want to put a family budget in place that reduces your costs as much as possible. So, for example, do you need Netflix? Do you need Amazon Prime? Do you need to go out to eat that often? Maybe you guys love to go on vacations. Can you pause that or take cheaper vacations for a while? So, how can you bring your costs down so that you can get by on just one income? And that will allow you to start diverting that money that you're saving into a savings account. Now, you can borrow money. I do encourage you to do this cost reduction, this budget reduction exercise, even if you're going to borrow money, because the fact is that the more money you save, the less money you spend, then the less money you have to borrow, the less money you have to take out of savings. And so still you're going to want to reduce your budget and your dependence on that second income. Uh, you might say, you know what, we're going to downsize our housing budget. Maybe we're going to live with a family member or take on a roommate or something like that who's going to help cover our expenses. These are good ideas. I strongly suggest these things. But reduce your household expenses. These same processes work if you are a single income household, and so maybe it's just you, or maybe it is a couple, but only one income. You're still going to want to reduce your reliance on that income so that you can divert money into savings and stash that away. So here's the thing. I love to see businesses speed up the time that it takes to start making money. And so you've probably already seen some of our social posts about reducing the time to first dollar. This is something I'm very, very passionate about. It's something that I want to encourage you to do. How can you shorten the amount of time it takes to do $1 to make your first dollar? A lot of businesses, a lot of business owners, they get stuck in this idea of I have to be perfect. I have to wait until I have everything planned out. I can't deal with uncertainty. Call me if you feel that way, because what we want to do is we want to see income coming in faster. Ideally, what happens is you have an idea. Well, what's the quickest thing I can do to see if my idea is valid? And how can we see, okay, what will people pay for this idea? And if the answer is, no one's going to pay for it, then you need to adapt your idea. And the shorter time periods you spend on doing these tests of generating income, then the more experiments you can do to find the one that actually works. All right, so hopefully that's a good answer. If you feel worried about how you can launch your business and make enough money and what you need to do to start, please, please, please call me. I help with that. Here's another question that came up to me. I won't disclose the person who shared it, but in this case, a person wanted to sell their business, and their business was going to include the building that they were renting. And so we had a nice long discussion about this, and I thought other people probably need to know about this as well. When you're selling your business, you have contractual obligations. Maybe it's with a vendor, maybe it's with a landlord. But let's just say that you're a year and a half in and you have a 3-year lease and somebody wants to take over the business. What do you do? So this process is called an assignment of lease. And essentially what happens is it works kind of like a sublet, but it's not. It's different. So in a sublet, if you had an apartment in college and maybe you had someone take it over for you, in a sublet, you are still on the hook. And so imagine this. Imagine that you're going to do one semester abroad and someone's going to pay your rent while you're gone. But if they stop paying the rent, you're still on the hook for it. An assignment is different. An assignment, you move the obligation away from you and permanently onto another person. And that person becomes wholly responsible for any obligations, and you are completely severed off that lease. That's what you want, is an assignment of lease. I see sometimes landlords demand that a renter for a commercial lease sign a personal guarantee. I don't like it, but it's necessary. And so we do that sometimes when the business is too new and it's just a big risk for the landlord. I get it. Landlords need to be protected. And so if you signed a personal guarantee for your lease, then if you are assigning that lease to someone else, then you would want to be released from your personal guarantee, and the new tenant might have to sign a personal guarantee. And sometimes that takes a little bit of a battle. If you are my client and you are a commercial landlord, I will help you make sure that you are protected. And if you are my client and you are a tenant, then I will help you negotiate this deal so that it works out successfully for both you and the landlord. Because typically, when someone's selling their business, we want it to be a win-win situation. So these are absolutely doable, but we want to make sure we cross our T's and dot our I's and get it done properly. All right, this one came up. Someone called me, texted me on a weekend, and this was the gist of their question. Can I have a handshake agreement for a lease or a land lease? And the answer is no, no. Every law student that's been in law school for at least a year can answer this question in their sleep, and that is, there are certain kinds of contracts that absolutely must be in writing. And when land is involved, when marriage is involved, when surety is involved, those things must be in writing. So if you have a prenup agreement, it has to be in writing. If you're going to pay someone's debt, that has to be in writing. And if you're going to do any kind of a lease or land contract, it absolutely must be in writing or it is unenforceable. A court will throw out a case where a land or lease or something like that for real property, which is land, is not in writing. All right. How are unemployment rates calculated? This is an easy one. I don't know. Oh, sorry. No, that's not the right answer. Unemployment rates are calculated in a very, very odd way. And so I don't want to say who shared this question. They asked not to be disclosed. But they might have gotten an email yesterday from the state bragging about how unemployment rates in Iowa are currently doing better than the national average. And I think the unemployment rates in Iowa are right around 3.4%. First of all, I'm going to express a little opinion, and that is too low. I don't like to see people unemployed, but I also don't like to see unemployment rates so low. What that means is that employers are struggling to find workers because there's not enough people looking for work, or if they are looking for work, they're getting premium rates. And so there are some parts of the United States where there are plenty of workers. Iowa is not one of them. Iowa's unemployment rate is low, and it's causing a very, very difficult situation for employers. And so, yes, I don't want to see people unemployed, but boy, I sure wish that employers who make up the bulk of my clients could find people. How is it calculated, though? The unemployment rate basically works off of the rolls of people who are collecting unemployment. And so if a person gives up and they're no longer looking for unemployment, then that number is not calculated. That person is not calculated in the unemployment rate. That calculation is called the workforce participation rate. And so that number is usually somewhere between 60 and 70%, which I believe is where Iowa is now. And that is different than the unemployment rate. Obviously, there's a big difference between 3.5% and 40%, which is the comparable number for participation. So if you are unemployed and you are not collecting unemployment, then you are not going to show up in the database that this unemployment rate is calculated from. So it is a generalization. All right, next question. Sam mentioned this one. Is rev share a good idea? And what do you think about typical rev share agreements that you would see in a game dev space. And so Sam is very interested in the idea of the commercial marketplace for games. And so this is the first question that he proposed. There'll be another one coming up. And so I will say this, that I think that rev share is a good idea. And so the typical agreements, the next question is gonna dig into the typical agreements more. But I will say this, that the things that I want to make sure is that I want to make sure that we know how long an agreement is good for, and I want to make sure that I know who has what rights. And if we know those things, then I think a rev share is a good plan. Now, this is going to dovetail in with another question coming up, is I want to make sure that it's very clear if this is or is not a partnership. Sometimes people enter into what is called an accidental partnership. Accidental partnerships are dangerous because they are that is what I call an unlimited liability business. And so a limited liability company reduces a person's personal risk for a business activity, but a accidental partnership basically shifts an infinite amount of risk onto a person personally. And so we want to make sure that any rev share agreement makes it very clear if there is a partnership or not. And if there is a partnership, then that needs to be very clearly documented. And so you are absolutely going to want rev share agreements reviewed by an attorney. But here's why I think that they're good, and that is that on any team, that you're going to have a person with one skill strong and one skill weak, and that person will hopefully have another person on their team who can complement their skills. And so, for example, you might have a person who is an excellent developer and maybe even an artist. And I actually know a few people who are good even at the audio, which is a part of game dev that people don't think about often. But maybe they are not a good marketer, or maybe they're not a good negotiator. Maybe they don't understand the psychology of sales. And so for them to partner with someone who is going to take it to market is a very, very good idea. And so we see this a lot with people who self-publish books. They will write a book, an excellent book, and they will self-publish it, and they will get no sales. And that is because there's a separate skill. You can't just write a good book and expect everyone to buy it. You need to help them find out about the book. And you have to price it right, and you have to have a good cover art, and you got to get reviews and things like that. Same with your game. And so I do think that rev share agreements are good. And the Apple iOS App Store and the Google Play Store are essentially rev share agreements, because those stores, and there's other ones too, Steam, whatever, they take a percentage of the gross sales, and they provide services like payment processing, customer support, things of that nature, that makes it easier for game developers to market their game. All right, so Sam's next question. Let's say you wanted to get together people from all around the world to work on a game. How would you set up the legal for that? And what's the best way? So there's a couple things going on here. So first of all, we see some activities that are purely voluntary. And so these are not legal entities. They are just groups of people who are not working in a commercial environment. And so something you might or might not know about me is, before I was an attorney, I was a software developer, and I worked for a company that released open source software. Open source software is software that is often given away for free with the permission to copy it and duplicate it and share with others. And so if you are creating something like open source, typically this is not done in a commercial setting. And you know how I talked a moment ago about accidental partnerships being bad? An accidental partnership is created when two people agree to go into business together. But when a group of people collaborate on something that is not commercial, then they don't have to worry about that accidental partnership happening. So generally speaking, you don't have to worry too much about this. However, it is not a bad idea for there to be a terms of service or other kind of agreement that clarifies what the nature of this community is. So that's one thing. Another thing that's going on here that people need to be wary of is that when you make a contribution of graphics, computer source code, other things of that nature, then you as a contributor might hold the copyright to your contributions. So for example, let's just say that you are a an artist, and you create an image of an elf holding a sword, and you contribute it to the game development so that that elf can be in the game walking around. Well, you hold the copyright to that elf unless you have done something to transfer that copyright to the community group. And in that case, the community has a little bit of a challenge here because they might have these contributions from people all over the world, and each of those people has a copyright interest into this whole product. That can make distribution very, very difficult for these communities. And in fact, there is a open source video program called VLC, and the developers created an Apple iOS version for it. And some of the people in the community for VLC that contributed code objected. They didn't like Apple, so they objected to their contributions being included in the Apple version of the program. And so a copyright strike was placed against the company and the program was taken down. And in order to clear up the copyrights on this, the VLC community had to really spend a lot of work. So the way that we deal with this in communities of non-commercial situations or even commercial situations is that we create a special contract called a CLA, which is a contributor license agreement. And it basically says that if you want to give us your graphics, your sounds, your code, whatever, then you're going to give us a license to use it for whatever we want or for these purposes. And so a CLA is a good way to make sure that when you get people together to work on some kind of a collaborative, creative project, that the organizers of that project know what to do. All right, one more question from Sam. What does a game publishing agreement look like? It looks like a big, long contract. And so I have such a contract that I can customize for clients, and I basically made a table of contents, and it is not very huge type, but here it is. So first of all, what we're going to see is one of our components of such a contract is that there's going to be a grant of rights. And this is kind of like that CLA that I mentioned, that contributor license agreement. It defines who has what rights. Oftentimes, if we are doing a contract of this nature, and this is true if you're writing a book, a movie script, orchestral piece, a video game, the next AI program, it doesn't matter. If you're doing something that has a copyright on it, then you're going to want to make sure that we know what rights the publisher has. And so do they have the right to translate it into a new language? Do they have the right to distribute it worldwide? Do they have exclusive rights? These things need to be clarified. And so that usually requires a lawyer and the team of people who are granting these rights to work together to work that out. We also need to have a method of delivery. How are the game developers or the musicians or whatever going to deliver that material? What obligations continue after the initial delivery? So if you are Taylor Swift, you might not have an obligation to update your song, but if you are creating a new antivirus software, you might have an obligation to make sure that it supports the newest viruses that come out. You're going to have to decide and specify in this contract who is going to provide what kind of support. Oftentimes, people who create these products are not that interested in providing the general support. And so a publisher may provide frontline support and then only escalate very challenging support questions to the creators. Consideration, this is a geeky law word. Consideration means that there has to be some kind of payment or other benefit transferred each direction. So I've created this work of art. I'm going to let you publish it. In exchange, you are going to give me something of value. It could be money, and oftentimes that's what we care about, but it can be something else. So it could even be, I'll let you do this as long as you promise not to sue me. That's what a settlement agreement says. But there has to be some kind of two-way transfer of value in order for such an agreement to exist. You need to think about sequel rights. If there's going to be a version 2, does the publisher get access to that? What about publication obligations? If you, let's just say that you make a contract and it's $50,000, I give you my game and you give me $50,000. Well, great, Does the company have to actually publish it, or can they just bury it and give you a check for 50 grand and then never release it? You want to make sure that that's clear. And so we see that with movie scripts sometimes, where things get purchased and never actually used. We need to know how long this agreement is going to go for, and then what happens if you want to break up. There also might need to be some confidentiality clauses. At the very least, you're likely going to want to see protections for any intellectual property, copyright, trademark, or whatever. Now, here's another one that is commonly not thought about enough, and I see people get into trouble with this all the time, and that is there needs to be representations and warranties, even if the only warranty is there are no warranties. But there is this thing called implied warranties, and implied warranties basically mean by the nature of its existence, I expect it to do something. If you go to Walmart and you buy a toaster, and you see a picture on the outside of the box of a toaster and toast coming out of it, it better make toast. And if it doesn't, then you've breached your warranty. You can't put a disclaimer in fine print on the box or inside the box that says doesn't actually make toast, because you've basically promised them it makes toast. So you need to clearly spell out what is promised and what is not being promised. Usually you want to have some discussion in the contract about damages and disputes. And so oftentimes we like to see people resolve matters quickly and efficiently through arbitration. That might not be the right way to do it. And then indemnification. If one party screws up, is the other party responsible? That needs to be there in as well. So this is kind of a short version of the things that I like to see in such a publication agreement. So thank you, Sam, for your question there. And so that is hopefully a pretty comprehensive answer, but ultimately you are going to want to talk to an attorney. Let's go to the next one. Here is one of the more challenging questions that I have had to think about in the AMA yet, and that is getting an HOA board to follow the rules. And the person who submitted this question asked for privacy, or did not ask for privacy, but I did not feel comfortable sharing their name because I see that there's probably going to be a dispute in their future. So can the board be made to pay for attorney's fees? So in Iowa and in many states, HOAs are typically nonprofits and they are typically corporations. And so therefore, the Iowa law for corporations applies to HOA boards. Now, that is not an absolutely true statement. And so ultimately, I have to say there is an "it depends" tacked onto this answer. But oftentimes, an HOA is a nonprofit, and therefore they are subject to Iowa's corporation laws. Iowa, and as far as I know, every state has the idea of a derivative action for corporations. And this is very hardcore geeky stuff, very commonly misunderstood. If you've heard of a derivative action, it might be in a movie like, hostile takeovers and things like that. And so a derivative action is brought by shareholders of a company or those who are an interested party in the company against the board. And it basically says that the company or the organization is being harmed because the board is not doing their job. And derivative actions are almost always ugly litigation matters. And they are brought by, if it's a nonprofit, then members of the nonprofit, or if it's a corporation, then shareholders of the corporation. So this person that said this question is actually on an HOA board, and as a board member, they do not have the ability, the standing is the legal word, to bring this lawsuit. They can only bring a lawsuit if they are a member of the HOA. So I don't own any Ford stock that I know of. Maybe in one of my investments I'm holding some, but I don't own any Ford stock. I therefore cannot bring a derivative action against the Ford board because I have no standing. I'm not affected by their rules. I may not like the rules, but I'm not affected. I can only do it if I'm a shareholder. Likewise, if you are a board member who is not a member, you don't have a house in the homeowners association, then you cannot file a derivative action. And so the derivative action causes a court to force the board to do a thing that they should be doing. The winner of the derivative action may be able to collect attorney's fees and other legal fees from the board, from the HOA. So this is kind of a lose-lose situation if you are an HOA member. And so let's just say that your HOA has $2 million set aside, and the HOA board members are not doing what they should, and it's harming the HOA. So the HOA member brings a suit against the board members, wins, and then their legal fees get covered by that $2 million that's in the HOA bank account. So that means that lawsuit harms the members of the HOA because some of that money that was meant to be spent for improvements got eaten up by legal fees. So this is typically done when the actions or inactions by the HOA board or the whatever board are so harmful that that spending the money on legal fees is an improvement. So if you need help with a derivative action, please talk to me or some other attorney, and we will help you. For nonprofits, I refer that to a friend. I have someone that I trust to handle nonprofit work. For corporations, I usually am helping the business and not the shareholders, but you should still start a conversation with me. And if I can't help you, I know who can. All right, here is another question brought by Dean Stevenson. He asks some great questions. He says, what does Matt mean by accidental partnerships and why are these bad? All right, I don't like accidental partnerships. A partnership happens when two people agree to do business together and then somebody takes action in furtherance of that agreement. And so what that means is, let's say two people say, they're sitting at the bar at night, they've had a couple drinks and they're like, oh yeah, we should totally do this. This is a great idea. We're going to make millions of dollars. And they decide that they're going to go into business together. Have they created a partnership? No, they have not. But the next morning, one person wakes up and says, great, we're going to go take this to the world and be ultra wealthy. And so they go open a bank account or sign a contract or buy equipment or whatever. Now a partnership exists, because at least one of the partners has now initiated some kind of action in furtherance of that partnership. And the other person might have just been joking, right? They weren't in their right mind, and so that might get them out of it, but it might not. Here's why accidental partnerships are bad. So if you have a limited liability company, then what we do is we build a nice strong wall so that if your business gets sued or has some obligation that it cannot handle, then you, the owner, you're not going to have to cough up your house or your 401k or your boat. That stuff, your personal possessions, are protected. Now, that might take a little work because someone might really want your boat or your 401k, but for the most part, if the LLC is done properly and the owners have set it up properly and maintained it properly, then they will not be personally liable. But in a partnership, you do not get limited liability, you get unlimited liability. So imagine two partners. One decides to go get a pickup truck for the business, doesn't tell the other partner, goes and spends $60,000 on a new F-150, and then drives it into a pole, and then decides they can't pay for it and they leave the state. Well, when they signed the payment for that, they said this is a business partnership, and they listed the other partner's name without their permission. Is the other partner responsible for the truck payment? Yes, they are. Now, another one of those it depends situations, but generally speaking, yes. If there's a partnership, even if it's a little bit of a surprise, if there is deemed to be a partnership, then any partner can be 100% liable. Now, that liable partner can try to go after the irresponsible partner to get their money back, but they may or may not work. If you are a car dealership and someone owes you 60 grand, who are you going to sue? Somebody that you can't find and is not very responsible, or someone who you can find and has money and a boat and a 401k? You're going to go after the responsible one and then let them figure out how to make it right. So that is what I mean by accidental partnerships. That is why they are bad, because they are unlimited liability. We don't like it. Oh, that's a carryover. Okay. What information about a terminated employee can you share internally? So this was brought by a business owner. I don't know if this business owner has actually terminated an employee, but presumably they have or are thinking about it. what can they say? And I edited their question way down to avoid disclosing too much information and to make it fit on that slide there. And here's the thing. You're going to want to avoid talking about it too much. And this can be very, very discouraging. And so if an employee is terminated for cause, then you can say, this employee is no longer with us, they were terminated, and something like that. Now, if the employee leaves on their own and they say, yeah, tell everybody I'll miss them, then you're relieved of your duty to some extent. I would still play it very, very safe though. But for the most part, if an employee is terminated, you are not going to want to say really anything bad. Because what will likely happen is that employee will try to bring a defamation suit against you. And a defamation suit is only good if you make an untrue statement, either in writing or verbally. But what happens is employees will try and they'll make your life miserable if they want to do that. So I would say, generally speaking, do not talk too much about it. And this can be difficult in small businesses as well. And so hopefully your employees are going to be understanding. And in fact, I think that you can and should put a positive spin on this and say, we are really disappointed that this person is no longer able to be part of the team. We respect their privacy and we wish them the best in the future. And for that reason, we are not going to talk about the details of their departure. And hopefully employees who are still craving to know, because don't we all want to know what really happened, are also going to respect that you're not bad-mouthing them, and so that if they ever have to leave, that they will hopefully get the same treatment. And so this is the best strategy. Same person asked another question, also still wishing to be confidential. How to fire an employee in a protected class for performance issues. Now, you might notice behind me, I'm not in my usual office space. I am actually at the Iowa Bar Association headquarters. Today, I am in a class about employment law. So this was a very poignant question, a timely question to ask. So here, first of all, I want to just say this. In today's world, I want you to think about everyone as if they are in a protected class. Even if they are not, they will be. Because if you are 40 years old and up, you are in a protected class. And so if you are a 29-year-old white male, you're not in a protected class yet, but you will be. And so just think of everybody as if they are in a protected class, because you just don't know. And this makes your life a little bit easier because laws about discrimination are changing constantly. And so today I learned about the Pumps Act, where it provides protections for new moms who have to pump. And so there are protections for women in this situation, and these protections are new in 2023, I believe. So there's all kinds of new things going on. Treat everybody as if they're in a protected class. All right, now that just simplifies this question. How to fire an employee for performance issues. Now, there are two kinds of performance issues that we need to answer. One is habitual performance issues, and one are very serious, egregious performance issues. And in this case, the person submitted the possible issue, and maybe it's on the next slide. Let me check. No, okay. Of an employee who shows up at work intoxicated or under the influence of drugs. Okay, that is going to be a very serious performance issue, especially if you're in an environment where a person is operating heavy equipment or something along those lines. And so if it creates an unsafe environment, you need to stop the worker's activity immediately. You probably need to send them home. And this might constitute immediate termination. Likewise, making threats of harm against an employee, other things that would be considered very, very serious, egregious issues could be immediate cause of termination. Certain kinds of disloyalty, right? Downloading company files and uploading them to another employer's website or something like that. You're going to want to shut that employee's computer off immediately and dismiss them. But it doesn't matter if it's an egregious issue or not. You're going to want to very carefully document everything about this. So if it is an egregious issue, there's going to be one document, and it's going to be here's the behavior that caused us to need to take this termination action, and then we terminated the employee effective immediately, and you're going to keep this in a file, and it's going to be in writing. And you can give it to the employee if you want. It's not a bad idea. Employees do like to know why they were terminated. Um, but if let's just say it's a less serious issue, let's just say someone's habitually late, then what you're going to want to do is, again, you're going to have a talk with them, and you're going to say, I'm going to put a note in your file that's saying that we had this talk, but here's the problem. You're supposed to be at work at 7:30 a.m. You have been coming into work between 7:45 and 8 a.m. every day. Is there something going on that we need to know about? And maybe they're having some very serious childcare issues or something along those lines. I hope that you would be understanding in those situations. And depending on how big your company is, you might actually be required to make some kinds of accommodations for certain kinds of issues like this. I did post in the Facebook group page earlier this week a very, very intriguing video by Dave Ramsey. And I sometimes love Dave Ramsey's answers and sometimes kind of don't. But this one was really good. In this particular video, Dave Ramsey advocates for being very, very generous and gentle with an employee who's having performance issues, like being sick to work or having a sick kid a lot or something along those lines. But you're going to want to document it, and you're going to want to make it clear what the expected behavior is, how they deviated from the expected behavior, and then what the process going forward is. And so I will put together some resources to share with the community related to creating a performance improvement plan. But this is something that you want to take seriously. You don't want to just have a headache in the morning and then start firing people because you're upset. That's just going to lead to all kinds of problems. But think about this very, very carefully. Has the employee recently engaged in some kind of protected activity? And so this is something that happens sometimes. An employee makes a complaint for something, and maybe they're right. Maybe they're right, and they say, you know what, this is unsafe. OSHA says that we're supposed to do this. We're not doing this, and the employee makes a complaint. If that employee starts getting written up, and then terminated, you're asking for a lawsuit. And so I want you to, as you begin this discipline process, I want you to think about, has the employee done something that would put them into a protected category? Because we do not want to retaliate against employees for doing something that employees probably should do. As a business owner, it is very uncomfortable sometimes to accept employee feedback. And you may or may not have to take actual action on that feedback, but it can be difficult to receive it. And if your response is, let's get rid of this employee, then you are opening yourself very, very seriously to an employment discrimination case or a adverse action case. And so if you are in doubt about what to do, I want you to reach out to me. Now, I do want to tell you, and I'm going to move to my last slide here. I do want to tell you that I offer subscription services to my clients. And the reason why I offer subscription services, which start as little as $95 a month, is that I do not want you to wait to ask me questions. If there is something on your mind and you need to talk to an attorney, if you have to go hire an attorney every time, then you're going to delay responding. And then you might put off something important, and we could snuff it out like a candle flame if we deal with it early. But if you wait, now it's a dumpster fire. So these subscriptions enable you to have my team available to you with any question that you have. So strongly consider having a subscription with us so that you can reach out if you have a question at any time. Even if you do not have a subscription, if you have questions about these, please reach out. We make it so easy to contact us. You can email us, you can schedule an appointment, you can text us. And so please don't wait to talk to us. If you would like to see more of this content, make sure you're subscribed. We're on Facebook, we're on YouTube, we're on LinkedIn. Wherever you're watching this, we are, and that way you get notified when we do the next AMAs, and you can submit your own questions. I'd love to answer them. For now, though, I will see you. This is Matt Newsom, the attorney with Surge Business Law.